Hello. Today I want to talk about a recent decision of the State Tenure Commission entitled Boyne City Public Schools versus Ringle. This is another case that delves into the changes made in the Teachers Tenure Act in 2011. And specifically in this case, the Commission looks at the change of a probationary status from 4 years to 5 years. The main change involved here was that when the probationary period was changed, the legislature grandfathered in those teachers who had begun their probationary period prior to the effective date of the amendment, which was January 19th of 2011. And so what the Act said was, if you began your probationary period before then, your probationary period remains 4 years. The Act, however, also said that that probationary period was subject to another provision which said that a teacher must be rated as effective or highly effective on their last 3 year-end evaluations. So in this case, Boyne City Schools sought a declaratory judgment from the Tenure Commission because they had a teacher who was hired for the 09-10 school year. That teacher had taught 2 years before the change, and then after the change taught 2 more years, with 11 and 12 being rated as minimally effective, and with 12-13 the teacher was rated as effective. So the district wasn't sure if the teacher, because they didn't have 3 years of effective or highly effective ratings, whether they were now tenured at the end of the 12-13 school year. The Commission said yes, they were tenured. The reason being is when it analyzed the two provisions together, the Commission said we have to look at a few different things. One is the purpose of the grandfathering clause, and we have to read anything consistent with that purpose and the purpose of the Act overall. We also can't change the language of the statute or read into it things that don't exist. Finally, the Commission said we have to try and avoid absurd results. So looking at the situation, what the Commission said was, the legislature specifically said that a teacher must have 3 consecutive effective or highly effective ratings. And so we can't read that to say 2 or 1 effective or highly effective ratings. It also said that we can't read satisfactory or unsatisfactory under the old system to be the same as the effectiveness labels. The effectiveness labels were put in for a purpose. They were also put in 2011, and so we can't look at previous evaluations and try and equate them to the effectiveness labels. Finally, the legislature said if we require the teacher to teach 3 years after the amendment and be rated on an effectiveness label, then the grandfathering provision is useless, and it's an absurd result, because essentially what would happen is a teacher who taught 3 years before the change in the Act would have to teach 3 more, thereby giving them a 6-year probationary period rather than a 4-year probationary period. So what the Commission settled on was to say that the only time the 3 consecutive years matters for a teacher who began their probationary period prior to July 19th of 2011 is if they taught 1 or less school years prior to the change. That way they would have 3 years after the amendment to the Act and 3 years to be rated on an effectiveness label rather than a satisfactory or unsatisfactory label. So in the case of Boyne City, for example, the effectiveness labels didn't matter. The grandfathering provision trumped the subject to language, and the teacher was considered to be tenured. If you have any questions about this, please feel free to let us know. But again, the key on this is going to be that unless the teacher has 3 consecutive years being rated on an effectiveness label under Section 1249 of the Revised School Code, that the subject to language of the Tenure Act does not apply. Thank you.